G'day everyone, and welcome to the third video in week 7 of our legal ethics course. This week we're looking at the duty of a lawyer to avoid conflicts of interest that may affect our ability to represent our clients. We've already talked about the potential conflict of interest between the lawyer's own interests and those of the client, and we've talked about the potential for a conflict of interest if the lawyer is representing two parties concurrently. In this third video, we look at the ethical issues arising if you're acting against a former client. There are a number of circumstances in which a lawyer or a firm may end up acting against a former client. The most obvious of these is if a new client comes along to hire your firm specifically because they know that you've represented the other party in the past. Less perniciously though, these situations are quite common if the conflict is occurring in the context of a small boutique industry with only a few firms specialising in that industry. Similarly, it wouldn't be unusual for a situation like this to arise in a small town where there may only be a limited number of law firms to choose from. Finally, situations like this are quite common where two law firms merge or where one law firm is bought by another. Suddenly the merged firm has twice as many customers in its history. Let's start where we usually start, by asking what the solicitor's conduct rules say. Rule 10.1 says a solicitor and law practice must avoid conflicts between the duties owed to current and former clients except as permitted by Rule 10.2. We'll talk about Rule 10.2 later. The starting position is that a solicitor and a law practice must avoid conflicts between the duties owed to current and former clients. Two things seem to leap out at us from that rule. First, it applies to the solicitor and the law practice. This means that if you or your practice have ever represented someone in the past, then the rule is engaged. You might personally never have heard of them. In fact, it might even be the case that everyone who ever worked on their file in the past has already left the firm. Doesn't matter. If your opponent has been a client of your firm in the past, then the rule is engaged and the ethical ground is perilous. Similarly, if you come to a new firm but in a previous job you've personally been involved in representing someone who's now an opponent, well, the rule is engaged, and that may be enough to stop your current firm from being able to act. So it's a really full-on rule. Why though? Why does the rule exist? Well, that leads us to the second bit of Rule 10.1, which really jumps out at us. It refers to the duties owed to current and former clients. That means there must be duties owed to those former clients. What duties? Well, to work that out, we only need to look back 1 week in our course. Remember last week and our discussions about confidentiality? One of the principles we discussed last week was that the duty of confidentiality continues after the end of the retainer. So even though the retainer is over, you're still under obligations to that past client. Specifically, the obligation to keep their confidential information confidential, and by implication, the duty not to use that confidential information for the benefit of any new client against your old client. The key persuasive case here is a case called Prince Geoffrey Bolkiah against KPMG, a British case determined in 1999. It's not binding in Australia, but there's no direct authority in Australia, and so it seems to be the case we turn to. KPMG are a very large international accountancy and business management firm. In many countries, they also provide quasi-legal services. Prince Geoffrey of Brunei had retained KPMG previously in relation to some litigation that settled. Later, KPMG were retained by the government of Brunei to audit a government investment agency chaired by Prince Geoffrey. The court found that they were not ethically entitled to audit the work of Prince Geoffrey, given that they had previously advised him in relation to litigation. Lord Millett said, "The only duty to the former client that survives the termination of the client relationship is a continuing duty to preserve the confidentiality of information imparted during its subsistence." Now, fair enough, I hear you say. It doesn't take any particular genius to understand that no client is going to be happy to have full and frank conversations with their solicitor if there's any chance that the confidential things that they say might later come back to bite them. But what if the new matter has nothing at all to do with the previous matter? If they're completely different matters, then surely you won't be using any of the confidential information gathered for the previous matter, right? Well, to a certain extent that's true. The test used by the courts, if a court's required to rule on an objection from a previous client, the test is whether there is a real possibility of the use of the information to the detriment of the former client. Now that's an interesting threshold. It needs to be a real possibility, so that suggests something more than mere theory. But at the same time, it only needs to be a real possibility, not a real probability. So there's a wide discretion in the hands of the court as to where the dividing line is between permissible and impermissible. To make matters even more complicated, we have to consider what is known as the getting to know you principle. Every time I say that, I hear the song Getting to Know You from the movie The Sound of Music. The getting to know you principle recognises that in many cases, the confidential information we learn about a client goes beyond merely reading whatever they might send us in emails. By dealing with a client, we're learning about things like their attitude to risk, their financial position, their level of knowledge about the law, the way their business runs. All of these factors are potentially confidential information that might well be used against the former client. However, in the case where the getting to know you term was first used, a case called Jungschans and Elphick Limited, Mr. Jungschans sought to restrain a financier from using a large firm which had previously provided him with advice. The judge did not rule that these getting to know you factors emerged in every case. He said, the overall opinion formed by a solicitor of his client as a result of his contact may, in the circumstances, amount to confidential information. So from all this, you can see that there's an extraordinary amount of uncertainty. Getting to know you factors may or may not amount to confidential information. The use of confidential information may or may not be unacceptable, depending on whether there's a real possibility of detriment to the former client. At this point, bear in mind that right the way through this course, I've been trying to emphasise that ethics is not just about learning a bunch of rules and blindly following them. If you've taken that to heart, you've already worked out that the only safe approach here is to assume that if you've been asked to represent a new client against an old one, a conflict of interest exists. Honestly, it's the only safe or sensible call. But that brings us to Rule 10.2. You see, Rule 10.2 says that you can represent a new client against an old one under two circumstances. The first circumstance should hopefully be obvious by now. If the former client gives their informed consent, then it's happy days and there's no conflict. The second one involved what are officially called information barriers, but many people still call them by their former term, Chinese walls. The idea is that a firm may be able to seal off the confidential information provided by a former client. For instance, they might be able to only use staff who weren't involved with the previous file. They might ensure that those staff have no access to the documents on that previous file, not even to file notes that might yield impressions of the client. If this is done carefully enough, then it's really no longer possible to say that there is a real possibility of the former client's information being used against them. Courts have traditionally been reluctant to recognise Chinese walls, and it's not difficult to see why. It's impossible to police a Chinese wall effectively, and in smaller firms it may be impossible to have an effective Chinese wall at all. However, in more recent years, perhaps because of the increasing corporatisation of the legal profession, the law societies and the courts have become a little more permissive regarding Chinese walls. The Law Society has set out guidelines for the operation of Chinese walls, and a copy of those guidelines is in the materials for this week. The first thing that you're going to note when reading these guidelines is that they're super complicated. In most cases, even though Chinese walls are theoretically a thing, it's going to be far more sensible and far more cost effective for the client for you to simply not act for that client. Now, I have to tell you, as a new practitioner, it's vital that you be aware of these issues, but you're almost never going to be the one making the call. That will be a partner or an associate. And by the time you're a more experienced solicitor making these judgments, you will have had ample time to learn by observing. So, at the end of video 3 this week, we've learned that one of the key duties a solicitor has to their client is the duty to avoid conflicts of interest. This means avoiding conflicts of interest where the solicitor's own interests conflict with those of the client, avoiding conflicts of interest where the solicitor is acting for two parties concurrently, and avoiding conflicts of interest arising from the solicitor acting against a former client. In the final video for this week, we'll look at a special case of conflict of interest, which occurs when a solicitor is acting for family or friends. One more video to go.